No. Madam Chair, regulations is a law. Please, Honorable Minister Frank, my former student. Madam Chair, the minister will make regulations to regulate the sector. But these regulations need, listen to me, we have made so many laws whereby there are those which can be just laid, there are those which should be approved. And I want to state that having given the minister all the powers from the beginning up to the end, you make a mistake to allow him make regulations and he implements, you are in danger. This is a very leading sector. It is a coffee sector. It has a lot of revenues. He can even change many things. So, Madam Chair, I want to agree with my colleague from Uvuma that the minister may, with approval, I'm saying may, with approval of Parliament,
Honorable Nandala, the minister shall lay regulations before Parliament for better carrying into effect the provisions of this Act.
We can improve. The reason why I'm saying the minister may, it is right.
Shall.
Give me your ears for 1 minute. He may decide not to make the what? The regulation.
Why? We are saying he must.
So you're saying he must?
Yes.
So you're saying the minister shall make regulations with approval of Parliament.
Honorable Nathan. Honorable Katundu. Yes?
Thank you very much, Madam Chairperson. Ordinarily, we make the principal act. And under that act, the minister is given powers to make regulations or rules for purposes of implementing the act. The reason why we require sometimes to have those rules or regulations laid on table is for us to be certain that he has not exceeded his powers. However, if you say approval, then we go back into the process as Parliament into looking into those regulations. Actually, it's like we are now enacting another law. In any case, once you say approval, it means the House sends them to the committee, then they are brought back, and then we debate them all over again, like we are debating an act of Parliament. I would suggest, and really, because this is a honest debate between the Honorable Nandala Mafabi and us, very, very honest, and I appreciate my colleague's contribution. And the reasons are not very difficult to find. Honorable Nandala Mafabi is a coffee group, if I may call him so. So, let the minister make the regulations, lay them on table, and once he lays them on the table, then we have an opportunity to look into them. If we think he has exceeded his powers, then we will take him at that point. Otherwise, we can't provide everything to be debated as if we are going to go through another process of enacting a substantive law. Madam Chairperson, I'd like to caution the minister and indeed the entire cabinet. If you have been given powers to make rules, don't go beyond the powers you have been given. Make sure you only enact rules to implement for purposes of implementing the Parent Act. We have not given you powers to legislate substantively.
So can we have the amendment?
Having listened to the debate, Right Honourable Chair, I propose that the proposal by the Honourable Member from Buvuma be amended to read that the Minister shall make regulations and lay the same before Parliament. Beg to submit.
The Minister shall make regulations and lay before Parliament.
I concede, Madam Speaker.
To who?
We are the same.
Shall.
The Minister shall make regulations and lay the same before Parliament.
Thank you. Minister.
I concede to this amendment.
Thank you. On the same,
Yeah, Madam Chair, in most cases, regulations are good for implementation. But experience has shown that some ministers, when we tell them to make regulations and lay them on table, they sleep completely. Can we tag a period? Within which period? Because this is a very important sector. Can we say within 6 months? Yes. Information. And I propose that within 6 months, they read the regulations.
Yes, Right Honorable Chair. Actually, the member has an interesting proposal, but I just wanted to correct something that, just for information, Honorable Ministers hardly sleep. So they never sleep on the job, because we even find it difficult sleeping at home. But I agree, Right Honorable Members, while we are doing this, we just need to be mindful of one thing. Regulations are always evolving. So please, let us not take it to mean that after we have presented regulations in 6 months, there can never be any other regulations that come. So regulations, so you are saying the first set of regulations. I have no objection to that, Right Honorable Speaker.
Madam Chair.
honorable members, our issue on,
Yes, Madam Chair. First of all, I agree, the regulation can be made anytime. I think what my brother Bakubaganye, that one, what he was raising is we need to differentiate the two cases. When he has made the regulation, before implementation, it should be laid in the what? In the house. There are two things. Before implementation, it should be laid in what? In the house. It is up to him. If he has made the regulation and decides to sit on it, he cannot implement it until he has laid it in the what? In the house. So the regulation becomes effective when it has been laid in the house and agreed on. So me, why I wanted to make some, maybe for the first one, yes, we can say for this one, which is the first one, within 6 months. Anytime you make another regulation, unless it is laid, you cannot what? Use it.
Yes, Right Honorable Speaker and Honorable colleagues, once the law requires you to do some act, such as laying them before Parliament, until you have completed those processes, they'll have no legal effect. So definitely, they will not have any effect until they are laid before Parliament.
thank you. I put a question that clause 54 be amended as proposed by the Attorney General. Those in favor say and the contrary nay. The ayes have it.
Clause 54 as amended.
I put a question that clause 54 as amended stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 55.
Clause 55, I put a question that clause 55 stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 56.
I put a question that clause 56 stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 57.
I put a question that clause 57 stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 58.
I put a question that clause 58.
58. Madam Chair, 58 is talking about savings and the compensation, because we need the House to understand.
Honorable Minister.
The liabilities, we have employees, we are doing what? What are you committing? Because here it is saying you transfer savings to the ministry. Now, what about the employees? Those are the liabilities I'm looking at. The other one may be the one paying the coffee nursery, whatever, but the employees. What are you putting in the law about employees?
Section 58, clause 58 provides for the saving provision, and 58.4 provides that the staff of UCDA, Coffee Development Authority, may be redeployed to serve in the public service, subject to the availability of positions. Yes. Colleagues, yes, it may, because one, you must remember that the purpose of rationalization was to reduce. So there are some people in UCDA who are definitely not going to be redeployed. So where the positions exist, they will be redeployed. But there are some who are definitely not going to be redeployed. But that has been provided for. Thank you.
Madam Chair. We don't have that. A lot of it. Madam Chair.
58. Clause 58.
Clause 58.
Nandal had made a proposal on staff, and that AG had responded and said it's catered for already. So
Yes, Yona.
Thank you, Madam Chair.
On which clause?
58.
staff already catered for.
Madam Chair, whereas I agree with the change, where we are saying the board members and staff of the Coffee Development Authority shall be paid terminal benefits in accordance with terms and conditions of their services. Madam Chair, we have been here. We watched UPK being merged to Chambogo University. We know where the staff are as of today.
Honorable members, I put a question that clause 58 stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Title.
Honorable, before title, Honorable Kefa, Dr. Kefa.
Thank you very much, Madam Chair, for giving me opportunity to move this amendment.
Honorable Minister, listen to this amendment. Eh?
The amendment I'm moving is that we insert a new clause immediately after clause 12 to say that the minister shall report to Parliament on the performance of the functions under Section 5 at least once every financial year. And the objective of this, Madam Chair, is that there is fear in the community at the moment. And this is what we are trying to address. There is fear in the community that the provision of the promotion of coffee, the development of the coffee sector will go down. And this is helping us to put the minister, to create some accountability, to help the minister, to ensure that the minister regularly reports to Parliament on the performance of the sector. And we are assuming that with the investment in the sector, it's likely to perform much better. And that's what actually we are likely to see, which will be reassuring to the community. Thank you very much, Madam Speaker.
Thank you, Chair. I want to make a clarification that actually we appear before sessional committee every year when we present policy statement, and will be covered.
Honorable members, when you look at the Public Finance Management Act, Section 13, it requires every entity, every ministry to report on the financials and the physical performance of an entity whenever they are presenting the ministerial statement, the budget framework paper, and as members of Parliament, you should take responsibility in ensuring that you do your oversight role well. Yes, Minister of Finance, State.
Madam Chair, thank you very much. In addition to the public finance